Hello there, ASR founder back again. And when I looked, I noticed that my last video was something like December 23rd of last year. Wow, how time flies when you're not having fun. But anyway, we got some good news from the summer of last year, even though it's from a while ago, this particular court ruling. It's from the great state of Montana. It doesn't affect directly too many people, but it will indirectly affect a lot of people, right? Because there's only about 1 million people live in the whole state. I'm in New York City where it's, you have 1 million people in one county, something, in a lot of these places. I mean, in these counties. But anyway, let's talk about this positive ruling from the great state of Montana. It's the state of Montana versus Richard D. Hinman. And it was decided in June 14th of 2023. And it involved a so-called failure to register charge. Okay. He was convicted of not complying with the so-called, so-called sex offender registry out there in the state, right? He first had to register because he was convicted of a sexually based offense in 94, right? And he quote unquote served. I don't like to say serve. He was incarcerated for about 6 years because he was in locked up in November. No, what is that? June of 1994. He was released in July of 2000. Now, the initial law that was passed in Montana was passed in 1989. It involved like you're just updating your address and stuff like that every year, right? So there was a registry in place. Most states didn't have any registry at all until the 90s, but Montana apparently had one in 1989, right? And while he was in jail, there were a couple of amendments, and even though they changed the law a few times in 2003, uh, the Supreme Court, the Montana Supreme Court rather, addressed this issue and allowed them to apply these changes retroactively. Because they said, well, they changed it some, but it wasn't too bad, right? But in 1997, the year 2007, they made a whole lot of changes, and plus they made it for life, right? And this is the law he was convicted of not complying with. But if you look at it, when he was convicted or even charged when the crime occurred, well, actually, I don't even know when the crime occurred. I just know that he was in since 94. It was a 10-year thing, registration. And now, if you look at it, he was released in 2000. So in 2010, that's 10 years. So even if you believe in these laws, technically, he shouldn't have any type of requirements after that. But as a lot of you guys know, they keep changing it on you over and over again for those who are subjected to it, right? So the court finally came to its senses from because after 2007, besides making it for life, they put these other restrictions in, like if you live in this county, but if you go visit this county for more than 10 days, then you got to register there and all this kind of thing. I mean, you guys that are probably watching this channel, you're probably familiar with all these different changes. If you leave the state, this and all this bullshit. But anyway, they finally came to their senses and said, this now, since 2007, is a system designed to facilitate social ostracism, right? And this registration is more like punishment. And more importantly, also important, they said much of the info now provided to the public, that is, was not part of the criminal record when he first got the charge. Because a lot of you guys, maybe you challenged this, and they would say something, well, these we just open this up to the public. You know, this is public records and stuff like that, blah, blah. But your email address and all this type of thing that they put on registry in some states, that's not open to the public. All that's open to the public is maybe the date of arrest, your charge, indictment, and final disposition of the case. But they put a whole bunch of other stuff on the internet. Now, this is important too that will help a lot of people. Usually, it would be something like they instituted a registry in 1995 or something like that. So if your case happened before that, some states, very few states actually, they'd say no, you're not subjected to it, but 1995 on. But this is very interesting. It could help some people maybe because what this ruling says, even though there was a registry there, but the changes. So this can help people that are arguing the retroactive application ex post facto issues. Ex post facto, if you look at it, it just basically means that you should be able, if you are contemplating committing a crime, you should be able to know what the sanction is for that crime, and then you decide whether you want to do it. If the crime says, well, if you do this crime, you can face 10 years in prison and a $100,000 fine. So you know that. And let's say you do that, and then they say, oh, well, we changed it now. Now, after you already done the crime and you're already sentenced, well, we're going to change it. You're now facing 20 years and a $200,000 fine. Something like that. You're supposed to be able to look up the law and know what the punishment is. Not they keep changing it, especially if you're already sentenced. You're already sentenced, So even though there were because you look at it, most of these states instituted these registries in the 90s. So most of the people that's on it, their crime occurred after that. But if they keep changing it, it's something you can use. This is what they would call persuasive authority for most of the people in the United States. It's not mandatory authority. It's mandatory if you live in Montana, but it's persuasive, meaning that let's say your state does this kind of stuff, right? And your state Supreme Court did not rule that it was unconstitutional. You can take the reasoning from this ruling and argue it in your state. And to try it, it's called persuasive because the judge don't necessarily have to go by it because it's not, this is the Montana Supreme Court. If you're arguing this in, let's say, New York, the judge that's hearing this case doesn't have to go by what they do in Montana, but it's persuasive. But another thing it does is it rules that this is punishment. I mean, it found that this is punishment, the court rather. Because a lot of other judges try to tap dance around the issue. Well, you guys say it's punishment, but it's just like a civil regulatory procedure, this and that and this and that. When you have other judges say, no, this is actually punishment, it makes your case, let's say, stronger. And you can read this ruling. Oh, what you should also do before I leave this out, you should look up the registration laws in Montana and compare them to your state. Now, if the registration laws are worse in your state or about the same, then you have a good argument. But if your laws are more lenient, they can say, well, your judges will probably say, well, in Montana they have to do this and have to do that. Over here in this state, we don't make you guys do all that. In other words, they may say, well, we don't list your email addresses, something like that. But yes, it's something that you can use, and it's a positive ruling. He was charged with failure to register, and he fought it to the Supreme Court in his state, and they actually came to their senses and said, no, he should not have to register because he did everything he was supposed to do according to his sentence. And you keep changing it and changing and changing it. I don't have to beat a dead horse, but it's good to have some positive rulings every now and then, right? I'm going to put a link to this decision in the description box below. But sometimes my links don't work. So what I'll also do is put it on the Twitter page and have the link there also if the link doesn't work under the video. Um, if you like me covering this court case belatedly, well, it's only about 6 or 7 months old. Give this video a like, subscribe to the channel. You know, maybe I may say something else in the future you may like. But what I always say, if you dislike this, hit the dislike button 2 times just to be sure. Thank you for viewing it and enjoy your day.